Welcome everyone. I'm Lisa Jones and I'm Managing Director and Wealth Advisor here in Springfield, Missouri. And I'm joined by the other advisors in our office, Katie Randall, Brandon Lee, and Matthew Swadek. We're excited to have you here today. We have a lot of really good information. I think you'll find some of it very insightful. We're going to be talking about estate planning, and we're featuring our expert guest, Will O'Rourke. Will is a licensed estate planning attorney with our Prime Capital Financial office in Dallas. He has been featured in a number of publications that you can see here, including Business Insider, Yahoo Finance, and Barron. So Will has a wealth of knowledge he's going to share with us, and we're really excited to share that with you as well. In today's session, we're going to explore elements of estate planning, from wills to trustees to power of attorney, healthcare directives, all of those concepts. So whether you're just beginning to think about your estate plan or looking to update an existing one, I think this webinar is designed with you in mind. Will is going to share some practical tips, some common misconceptions and real life examples that's going to help us demystify the estate planning process. Plus, there is going to be an opportunity at the end of the webinar for you to take action and schedule either a private consultation to discuss your personal situation with Will. You can also speak with your advisor. This QR code will take this information to your advisor as well, because we want your advisor to be helpful in this process along the way. So each of you are currently in listen-only mode. You can type questions into the chat feature that's in this GoToWebinar. We'll monitor that and get those questions over to Will so he can answer them at the end. So right now, grab a notepad, sit back, and prepare to get some great information today. Without further ado, welcome, Will.
Thank you, Lisa. I appreciate that very gracious introduction. I don't know if I have a wealth of knowledge to impart, but hopefully there are some useful things that we'll be able to take from our discussion today. So let's talk about what we're going to discuss today. So basically, we're going to cover estate planning 101. Up to about estate planning 201. So we're going to discuss wills and living wills, which most folks are probably familiar with, the different types of trusts, setting up beneficiaries, proper beneficiary designation, and how to take care of consolidation in that manner, and then as well as power of attorney, so both medical and financial, as well as the durable aspect of those of power of attorney documents. So at any point, if there's something that piques your interest or you want to know more about, just scan this QR code. It'll be featured throughout the presentation, just so you don't have to go back and ask for a particular slide. But just click on that, and that will allow you to either submit a question or to request time to discuss a particular topic. So let's talk about the value of estate planning. And I love this example because I have a new 8-month-old son, and I remember, putting the car seat in the car for the first time, buying the car seat, little sticker shock there. But you don't buy a car seat because your kid needs a place to sit in the car, right? You buy it for protection and security so that nothing will happen to your children. So you do it basically to protect the ones you love, to preserve the hard work that you've done to be able to support and raise them, and doing so with an eye on the future, because how are they going to grow up to be big, healthy, strong, smart kids, future leaders of this world, if something happens to them at such a young age? So just like that with estate planning, we don't want documents that detail what happens to our stuff after we pass. We want what an estate plan provides, which is obviously protection for our loved ones, preserving what we've worked our lifetime for, maintaining the standard of living for those around us, and also setting up the ones we care about best for their future and also their heirs. So basically, in summary, just like buying a car seat or doing an estate plan, what we're trying to do is creating a thoughtful plan while investing in our loved ones' future and the ones we care about. So this, I'd like to introduce wealth.com. So previously, there had been a major bifurcation in the wealth management space versus the estate planning space, where a estate planning attorney would handle those documents, and on the wealth management side, you get investment advice, financial planning, and all that entails. However, so wealth.com is a new software that was just introduced to the industry It's won multiple awards, and it's revolutionized the way that wealth managers and estate planning can best come together to serve clients. So it's a massive benefit that we're really excited about, and a value that our clients otherwise did not have access to. So let's discuss what is estate planning. So first, what is an estate, right? So an estate is everything you own: houses, cars, boats, vehicles. It even includes personal property, diamond rings, jewelry, collectibles, but it also includes financials, so bank accounts, IRAs, 401ks, pensions, annuities, life insurance. So that's an estate. And then beneficiaries, those are the people that are going to benefit from your estate, whether it's by naming them or by state laws or by an instrument that you execute. There are different types of beneficiaries, whether intended or unintended, and the consequences that the beneficiary designations have will be discussed a little bit later. And then probate. So probate, what is that? It's a process, right? It's the name given to the process of legally winding up your estate and distributing it to other living people or entities. So there's a probate court in every county, right? And so what happens is after you die, you submit the will to probate court, assuming all is good. Probate court follows the instructions of the will and distributes assets to the proper beneficiaries. So what options are available for estate planning, and when are each of these most useful? So obviously we have the last will and testament. That's the traditional will that everybody is likely familiar with. That is probably the most common estate planning instrument that is executed. We also have revocable or living trusts, as well as irrevocable trusts, which are less common but can be very useful for tax purposes. But all of these tools seek to provide certainty from avoiding leaks and perils. Leaks are unnecessary drags on your asset in terms of unnecessary taxes, predatorial either beneficiaries or creditors, potential lawsuits between beneficiaries, and then also spendthrift beneficiaries, which are beneficiaries not too experienced or well-versed in managing funds or preserving assets. And then also perils. So when I think of perils, I think of grave turners, or things that would make you turn over in your grave if you found out that it happened after you passed. So we want to put the protections in place to avoid things like that, so nobody's turning over. So who needs estate planning? We're going to discuss multiple real-life examples and whether or not estate planning is necessary for them and what actions they should take based on their experiences and the folks that came before them. So basically, with everything you can have some solace knowing there's only three things that could potentially happen to your assets. One, they could be involved in an intestacy proceeding, which we'll discuss more about that. One, they can pass to a beneficiary by will. Excuse me. Two, they can pass to a beneficiary by will. Or three, they could pass to a beneficiary via trust. So let's talk about the key groups benefiting from estate planning and how they're benefiting. So first, we have business owners. These are people that have worked very hard to either build their own business, or they have worked very hard for their company that they work for and risen to such a crucial career point that they have to protect that interest at all costs. And estate planning can be very useful to protect those type of assets or business interests, stock grants, stuff like that. Potential heirs or future heirs of an inheritance. So when folks inherit a lot of money, it can be one, unexpected, but two, it can cause potential friction between other potential heirs or between spouses. So it's crucial to plan before you receive a large inheritance yourself. And then parents and grandparents. So it allows parents to decide who is going to receive or who's going to provide care for their children after they are gone. And also allows people to dictate what type of care they're going to receive and who is going to be providing that care. So in that sense, it provides a lot of peace of mind to those folks, and it allows you to dictate exactly how you want your legacy and wishes to be carried out. Blended families and special family circumstances. So this is more and more common, obviously. I call it the Brady Bunch example, right? But obviously divorce is much more common now than it was in previous generations. With that, you have remarriage, children from different marriages, stepchildren, and then also potential bad actors. So when the family tree starts getting so many branches, the potential for, you know, a niece to bring home a boyfriend that we're not too thrilled about grows, and we want to, you know, avoid our assets and ending up in unintentional hands. And then high net worth individuals, so estate taxes and probate can both be a significant drag on the estate that you leave your beneficiaries. Probate costs about between 1% and 5% of the assets that go through probate. So think if you have $1 million estate, that's $10,000 to $50,000. And then estate taxes, if you're above the estate tax threshold, that's also very state to state, but it can be anywhere from 10 to 20% of everything that is in your state over the estate tax exemption level set by the federal government. So let's talk about some misconceptions about estate planning. So, or I guess why people avoid it. So the number one reason is procrastination. People saying, I'll get around to it later, right? There's no rush because I'm in good health, everything's going fine. Well, not all of us plan or know exactly when things are going to decline or when is the last minute that we're going to be able to do this stuff. But getting it taken care of and just getting it off your plate eliminates that residual stress that you can be carrying around. It's too complicated or too expensive, so that's another common mistake. It's only as complicated as you make it. So you can make it as complicated as you want. You can give it each dollar you have to a different person and spell that out in the will, or you could keep it super simple. A good attorney will keep it as simple as possible in order to carry out your wishes, and should be able to pull back the veil of complexity that exists there. And then people say, I don't own anything of value. I don't, you know, I'm not rich or I'm not super wealthy. I don't need an estate plan because there's not much to give away. Well, they're more than what you think in terms of the estate. So that includes things like the family home, life insurance proceeds, retirement plans, 401ks, 403bs, annuities, stuff like that. It consists of everything you own, and that stuff not only can add up pretty quickly, but they can also continue to grow from now and up until the time of your passing, and the level they reach may surprise you there. And then next common one is people don't want to burden their loved ones with either, you know, discussing all of this with them, or having them be the ones to kind of facilitate their assets after their passing, whether they're appointed as executor or trustee. But I think it forces people to have that uncomfortable conversation, and it's a conversation to have, but it's kind of one of those rip the Band-Aid off things that, sure, it's a tough conversation to have, but sometimes you got to have those tough conversations, and usually when you're done with them, you're glad you had it. And then it's too depressing to think about. I run into this sometimes, you know, people don't even want to confront the idea of their passing, which I do understand. Obviously, death is a very upsetting and sad thing, and we hate to lose a loved one, but none of us can run from it. I don't know if there's anybody out there that's got the secret to youth or the fountain of youth, but it's all coming for us at some point, so might as well plan. So let's start with first, or the foundational piece of an estate plan, and that's the power of attorney. So power of attorney, there's both medical and financial, is a letter that authorizes one to act on another's behalf, either to conduct business, make personal decisions, or any other legal matter. So the person granting that power is the principal, and the person receiving that power is the agent. So if with a medical power of attorney, you're appointing someone you trust to make decisions about the medical care you receive, who you receive it from, and when you receive it. So it also allows you to, those folks to dictate to doctors and healthcare providers what your wishes were. Included with that, or under that same umbrella, we have healthcare directives or physician's directives, which allows you to stipulate what cares that you would not like to receive, or if you have a decision to be made on life support continuation. And then HIPAA authorization. So HIPAA is the law governing medical information and medical treatment. So that allows you to dictate who can receive information about your care, because otherwise that information is privileged between you and the doctor. And then guardianship of your person. So if you're unable to care for yourself during your lifetime, you're no longer able to care for yourself or for your finances, it allows somebody to step in and either care for both of those things, or one different person caring for you and one caring for the finances. And then the financial power of attorney. So this is who you're choosing to manage your finances during your lifetime if you're unable, and then also allows you to appoint a personal representative. Who a personal representative is not your trustee or executor, but it's somebody who can appoint a trustee or executor if there's not one still living, or not one appointed in the first place. So establishing a will. So obviously a will is what we're all familiar with, right? It's a legal document that sets out your wishes and where your property goes. We have 4 different types of wills. So simple wills, that's the one you're most familiar with. Just a simple document that spells out what you have and where you want it to go. And then we have testamentary trust wills, which these are wills that provide for the creation of a trust after your death. So a trust is normally created while you're still living, but a testamentary trust is one that's created from a will to best carry out the testator's wishes in the will. Joint wills, these are less common now, just around the marital property states and community property states versus separate property states. Since there's been a lot of states going back and forth or changing between one view or the other, those have been abandoned. It's basically one will for a married couple. And then living wills. So living wills are kind of a section or an addendum to a simple will that allows you to dictate end-of-life care for yourself, so that other family members don't have to make the decision on their own. So a will is great, but a will can't do everything for you, right? It may not be able to carry out all of your wishes or what you're trying to accomplish. So in terms of beneficiary designation, so when, let's say, a life insurance policy, for instance, on a life insurance policy, when the owner or the insured passes away, the life insurance company does not want to hear from the attorney or the executor or whoever's administering the estate. They're not going to listen to the terms of a will. They're going to go right to the beneficiary, the listed beneficiary on the policy. And so basically that trumps whatever a will says. And then also business ownership. So if you're a business owner, you own a partnership interest in a private business, normally you're not able to just pass that stuff down due to buy-sell agreements or other company agreements. And the legal contract that you signed before would basically invalidate anything you tried to do in the will to pass those interests down. And then beneficiary designations that are due to special circumstances. So if you have a spouse, right, that you're married to, but you choose to pass a life insurance policy or retirement plan, list another beneficiary other than your spouse, that could cause a lot of problems, and even a will won't be able to mitigate that. A will can also, it does not avoid probate, which means that it does not reduce or mitigate potential estate taxes, which we discussed. The potential cost of those 10 to 25% of your estate value over the federal exemption. And then special needs, so dictating the type of care and covering that type of care financially for any special needs family members cannot always be carried out in a will. And then avoiding probate. So a will goes through probate, and ultimately, if there's any folks that have been through probate, we want to avoid it because it's costly, time consuming, it's public, meaning that your will is made public information, and basically your dirty laundry is aired out. Everyone is able to see the nature of your assets and where they're going, which is not always a good thing. So what we're really trying to do is care for our loved ones, and I kind of call that leaving a legacy or framing your legacy. So in terms of the instrument that could give you the most versatility and the most tools in your tool belt to do that, we look at revocable trusts, or living trusts as they're sometimes called. So possible threats to wealth. Okay, so divorce, right? Obviously, that's a no-brainer there. We know that. Creditors, people that are trying to collect money, cyber scammers, and undue influence. So this one is on the rise. Basically, people that are either misleading senior citizens or other vulnerable folks included in our population to basically, you know, pull the wool over their eyes and try to get their hands on some of those funds. And then destructive family dynamics. Everybody has their own separate family circumstances, and sometimes things can get a little hairy between members of the family tree. So that could potentially, diminish what you were trying to accomplish ultimately. Self-destructive behavior. So think of spendthrift activity or addictive behaviors by potential beneficiaries who may squander the wealth that they would have otherwise been able to pass down to their beneficiaries. Folks with poor money management skills, folks who receive too much too soon or too much wealth all at once. Sometimes that can be too much of a burden, one, just because someone can become overwhelmed. Two, it can be a bad tax strategy if you're inheriting assets while you're in your peak earning years. And three, it may, like we said, lead to poor decision making. And then predatory caregivers. So these are people who were not too interested in hanging around grandma while she was alive or previously, but as soon as she found out that maybe grandma's not doing so good, they show up as in the guise of a caregiver, but really they're there to ultimately either convince the grandma or the future testator to name them as beneficiary for certain or all assets, or to reach those assets while folks are still alive. So we all want to avoid the unemployed nephew who we haven't seen in 30 years, all of a sudden starts coming around. And I don't know if there are any Chevy Chase fans out there, but we call this the Cousin Eddie scenario, right? We all want to avoid the Cousin Eddie scenario. We're not happy when Cousin Eddie shows up for Christmas, just like Chevy Chase and Christmas Vacation. So it's something we want to avoid. So who needs a trust then? If those are all the issues, and who falls in those categories? So trusts are for folks that are trying to accomplish either one or more of these 5 things listed. So either avoiding probate, realizing a higher degree of privacy to avoid that Cousin Eddie scenario that I talked about, immediate access and distribution to beneficiaries after your death instead of waiting for the time of probate to be completed, and then retaining control over your wealth after your death. So you can control to a certain degree of certainty how your money is going to be spent and how much of it, or gifted to your kids or other beneficiaries, instead of giving them all a lump sum at once and just hope it ends up benefiting them. And then legacy through stipulation. So some common scenarios here are, hey, I'd love to give my kids their portion of the state, but first they have to graduate college, or you get the second half after you get married. So it allows you to kind of stipulate what conditions you'd like to have folks meet, or what legacy you would like to ensure kind of continues on in your family after your passing. Excuse me. So let's talk about establishing a trust and how that works. So a trust, basically, the effect of it is you're transferring legal title from yourself to the trust. And what happens with assets in a trust after your death is assets in a trust do not go through probate. So ultimately, the end goal is to get everything you can into the trust so that there is no estate to probate. But the parties to a trust include the settlor or the grantor. That's the person who is ultimately creating the trust and funding the trust with assets. The trustee, oftentimes that is the grantor during their lifetime, and then after their death, they would appoint successor or alternate trustees. You can have individual trustees, which are an individual person. If you trust somebody that you have a relationship with very well with how to deal with your estate, and that they will be able to responsibly manage and efficiently manage those funds. And then we also have corporate trustees. So this is more common, I would say. Folks appoint, for instance, like a Bank of America or a Goldman Sachs to be the trustee to care for, to manage those funds on an institutional level for all the beneficiaries. And then there are obviously beneficiaries to the trust, Same designation as a will. These are the people that stand to inherit the assets that are located in the trust. So let's talk about types of trusts. So we spoke about revocable trusts, obviously, which are trusts that can still be amended during a testator's lifetime. Under that umbrella, we have AB trusts and continuation trusts. AB trusts are sometimes important because they allow a portion of your marital assets to be preserved for your heirs instead of everything going to your spouse after your death. And this can be important in case of, say, you may want to protect yourself from the scenario that after your passing, your spouse marries somebody who unknowingly they were a bad actor and were able to reach assets that you had left for your wife and kids after your passing. So an AB trust is good, helping protect from those types of scenarios. And then continuation trusts, which are trusts that are for your other beneficiaries in the trust, but they don't become eligible to receive the assets from those trusts until maybe a certain age is met or a certain requirement is met after your death. And then ILETs, these are irrevocable life insurance trusts. And with an ILET, basically the grantor is transferring your assets from yourself to ownership of the trust. It's an irrevocable gift. It cannot be undone in your lifetime. However, these are a massive tool to get assets out of your estate if you're nearing that estate tax exemption, and to shift a lot of lifetime tax burden to defer it to later when the beneficiaries realize the death benefit. And then a special needs trust. So many folks have special needs people in their families, and a special needs trust is a specific addendum to a revocable trust that allows you to dictate the care and support that those with special needs will receive after your death. So do I need a trust? Do I need a will? Do I need both? So let's talk about the pros and cons. So the pros of a trust: it avoids probate, like we said, minimizes estate taxes, allows the assets to be managed by you until you're no longer unable or unfit to do so, or by somebody else who is. What are the cons of a trust? So it's a little more costly upfront than a will. It may cost you some time retitling assets or redesignating beneficiaries. And then if it's an irrevocable trust, obviously it would be impossible to change after creation. So definitely things that need to be considered. And then a will. So a will is easier to do yourself if you're a do-it-yourselfer. Changing a will is easier to handle in some cases, and the cost up front is lower than a trust is. So the cons, obviously a will goes through probate, and you paid for the will to be drawn up before your death, but afterwards probate is also going to cost your estate and ultimately your beneficiaries. So depending on the length of probate and the nature of the assets, the complexity of the family and things like that, it could be a bigger burden than you would expect. Obviously, like we said earlier, wills are public record, so Cousin Eddie might be looking out to see if he can finally get his hands on that Winnebago. And then wills do not provide for any sort of mitigation against estate taxes. So like we said, there are the three outcomes. We have talked about a will and a trust. We have not talked about intestacy, so let's visit that. So intestacy is basically the process that occurs when somebody dies without a will that is able to go to probate, or with assets that are outside of a trust that do not have any designation as far as beneficiary goes. So when someone passes without an estate plan or a valid will, they're known as intestate, which depending on the state that you live in, dictates the flow of intestate, or I guess the flow of your assets, how that would occur. The most common scenario is that first, if you had no will in place, everything would go to your spouse. If your spouse was not alive, everything to your children. If they're not living, to your grandchildren, and so forth. If you have no living children, it would go to your parents. If your parents are deceased, it would go to your siblings. Siblings are deceased, it would go to their kids. And if all those folks are passed, it goes over to the right column, as you see. But as you could probably guess, the more I guess rungs you go down that ladder, or the farther over you go in that flow chart, the more parties that are involved, and the more potential that somebody that you did not intend to receive a benefit from your life's work would be able to get their hands on something. So let's talk about do I really need a will if, maybe in testacy everything will just go to my loved ones without even having to do a will, and I won't even have to take care of it. So either way, you have to go through probate or an intestacy proceeding, which is almost the same as probate, just without a will. But without a will, you're looking at a cost of $2,500 to $3,000. That's just in court fees. If you try to conduct the process yourself. If you hire an attorney to settle a loved one's estate, that's probably going to run you something over $5,000 just for their time. Without a will or any direction, it's going to take some serious fact finding and due diligence on their part to settle an estate, and then also assumes that potential heirs would agree with how the estate is split. So if you don't have anything in place and Bobby thinks that he was going to get the 1968 Corvette, but Jimmy also wants a 1968 Corvette, if there's any type of family conflict or conflict between beneficiaries there, that could also result in a cost. And then if you have to submit an application to determine who the rightful heir is, obviously now you're starting to get up there more towards $10,000. So the cost of probate with a will, so to get a will set up or proper estate planning documents, usually you're starting about $1,000. I would say on the higher end of the middle of the bell curve, there's $5,000. Occasionally you do see something over $5,000, but usually that would involve some complexity there. Then you're going to have court costs of $300 to $1,000. So the good thing is that if you have a solid will and it was executed properly, your costs are kind of capped there. You can name an executor in your will who's going to be the person probating the will and kind of facilitating the distribution of assets. That person is allowed to retain their statutory executor's compensation from the estate, which usually varies between 1% and 3% of the value of the assets. Often this compensation is waived because usually an executor is a child or a spouse or somebody else who's doing this job out of the goodness of their heart. So who needs estate planning? Let's talk about specific circumstances and stories that folks have, their experiences, and ultimately the solutions that are best for them. So first we have Jack Jones. So Jack is 60, he's married, he's got 2 kids who both have 2 kids each. He's approaching retirement. His net worth is about $500,000. He does not have an estate plan, but recently he lost his mother, Susan, who before Susan passed, Jack's father had predeceased her. So Jack's father, Richard, made it a priority that in the event of his death, Jack and Jack's sister would avoid any complexities to settle his estate. And Susan left Richard's estate plan unchanged and passed away unexpectedly, leaving Jack and Amy without a plan to complete or settle her estate after her passing. So Jack, he's faced with a couple challenges here. First, it's his first time navigating the whole process of intestacy and distributing asset, and it's his mother's estate. Obviously, he's unprepared for the unexpected costs. He did not know that his mom was not doing well and did not have funds allocated for that because he's busy saving for retirement. And now this whole experience has him reflecting on his life. Okay, I'm working, all these years and up until I can't anymore to be able to take care of my family, and I would hate for them or any of that value that I've provided to be diminished because of improper planning. So what he wants to do is he wants to avoid the mess he encountered when he's settling his mother's estate. Like I said, minimize time, money, and energy spent by his beneficiaries on the matter, and establish an open line of communication with loved ones. So what we recommend to Jack in this situation is you need to meet with an estate planning expert to discuss more specific wishes. And then once a plan is in place, I believe it's imperative to have a conversation with your beneficiaries or those standing to benefit so they can be aware of what is going to happen after your passing, and then continue to have an open dialogue with your attorney as questions and concerns arise. So, and then we have the Smiths. So the Smiths, we have Wendy and Hank. They are both had previous marriages and both have adolescent children from those previous marriages. So Wendy is a C-suite executive making a good chunk of money every year. Hank is a middle management guy. Together they have a net worth about $5 million. 80% of that is derived from Wendy's separate property before the marriage. So they've never really given any estate planning any serious thought, mostly because they're both pretty healthy and relatively young. But since the onset of their marriage, the blended family scenario has kind of made the whole idea uncomfortable about who is going to get what and who's entitled to what. So understandably, they want to take care of this before it becomes something that festers, and make sure that each of their individual wishes are carried out, while also making sure that the surviving spouse is carried out. So Wendy, not only is Wendy doing well in the corporate world, she also inherited a large sum of money from her relatives, and she has, both her and Hank have kids that are still in the house, not out of the house yet. So the blended family combination has led to this uncomfortable situation, and Wendy wants some certainty with what's going to happen with her assets. So she wants to guarantee that the inherited money is earmarked for her children's college tuition. Hank is in agreement, and he is also looking to name guardians for his children if him and Wendy were to pass. And then also both of them want to ensure that their surviving spouse has sufficient funds to cover their needs for the rest of their lifetime, while also ensuring that their children are able to benefit as well. So we are going to, what we recommend to them is likely a trust in this scenario, where possibly an AB trust, where they would both be able to kind of dictate what their individual portions of the estate or separate property are divided and where those go. And then also proper titling of assets, whether transferring title to the trust or beneficiary designations, either designating the trust as beneficiary or by proper percentage splits that the two are able to agree on. And lastly, we have Tracy. So Tracy's 50, she's a widow, mother of two, both kids are out of the house, so she's a high school teacher. She has about $3 million now from a life insurance policy that her husband had, and she currently has a revocable trust. So Tracy's husband recently passed away and listed Tracy as the trustee of the revocable trust for the family. Tracy continues to work full-time, but also lives off the proceeds from her husband's life insurance policy. Tracy recently found out that she is soon to be a grandmother, with one of her children now expecting a child, or her first grandchild. So this announcement has led her to start thinking about her estate plan, and her husband's death obviously made her think about her own mortality. So basically the challenges that Tracy's facing is a lack of trust in her own self to, one, preserve the assets and monitor them as the trustee of her the revocable trust that her husband established, and then fear that her children's relationship could be jeopardized over improper agreement on how assets should be distributed. And the previous attorney that had done her husband's estate plan is no longer able to assist her. So what she wants to do is solidify power of attorney among her two children. So Tony works in finance. He's very financially aware, so we're going to have him execute a power of attorney for Tony over Tracy. And then Tiffany, her daughter that's a nurse, we're going to designate her as a medical power of attorney because she's best suited to make decisions about Tracy's medical care. And then proper beneficiary designation or provisions in a trust or will allow her to designate funds that are guaranteed to go to her grandchildren. And then also she wants a smooth settlement and an easy process like the one that she experienced after the passing of her late husband. So she should seek help from a financial advisor to either source a new attorney or to revisit her estate plan, and then involve her children in the process like we talked about, and then utilize a no contest clause because she's afraid of bickering and infighting, and ultimately that will solve that issue. So all in all, basically what I'm trying to say is there are many ways to skin the cat, or there are many solutions here that are ultimately going to get you to the same destination depending on your circumstances. So that destination is you put your family in the best circumstances and the best position after your passing to, one, be able to benefit themselves, but also for your legacy to be carried out. And that's what we're all trying to accomplish. And these are the four things basically that make up a legacy: assets left to the family, protecting those assets, the management and preservation of those assets, and then making sure that your wishes as well as everyone else's are respected and carried out. The benefit of estate planning with wealth.com. So wealth.com provides a great digital platform, very easy and intuitive to navigate with your financial advisor or otherwise. Wide variety of plans, documents, and options to choose from. Education is available if you'd like access to that. And an encrypted digital storage vault within the platform allows you to safely and securely digitally store those documents, as well as retaining a physical copy. So the types of plans offered by wealth.com suite. So we have the core plan, which provides you access to the platform, advanced healthcare directives or physician's directives, financial power of attorney documents, and then guardianship nominations. Then we have the will package, which includes all of those things, plus a last will and testament for each spouse, and then the trust package, which includes all of those things, plus an additional revocable trust for either a single person, married couple, or other family dynamic, which will include a pour over will to cover assets not otherwise spelled out in any other financial planning document. So those are the three packages offered through the wealth.com suite. Pricing guide. So how much is this stuff going to cost? So on the far side, we have the core strategy. The core strategy for an individual starts at $350. For married couples, it starts at $600. For individuals, the will package starts at $900. The married couples for a will package starts at $1,200. And then I don't know, I guess the formatting got a little messed up here. Sorry about that. But the third one, individuals, that's the trust package for individuals starting at $1,600, married couples starting at $2,100. And then lastly, we have an existing estate plan review. If you'd like us to review any documents that you already have in existence to make sure that they say what you're wanting them to say, that ranges anywhere from $100 to $250, depending on how many documents you have and the extent of those. So if anybody, if there's anything that anybody would like to discuss more, or if you're interested in kind of, hey, how does this whole process get started? If you provide your email through that QR code, we'll be able to send you this estate planning pre-meeting worksheet, which filling this out not only is a great exercise for you or you and a potential spouse, but it'll give you a solid start for that conversation or meeting with an attorney or with your financial advisor as a foundation for getting started with your estate plan. So in terms of what's next, like I said, through this QR code, you'll be able to access one-on-one consults and new estate planning recommendations through the platform, and then also reviews or potential revisions for your existing docs. So we are all wrapped up there, and I will pause for questions.
Well, if you'll go backwards to that slide that had the QR code, it also has a link. If you're watching this on your phone, you can click the link. All we ask is your first name, last name, and email address. Again, that information will go to your advisor, and then your advisor can talk with you about what other questions you have, what your personal needs are, connect you with Will, or even connect you with another financial planning, or sorry, estate planning attorney here locally or in your area. Well, we have a few questions, Will, for as we've been going through this. And again, if you're listening live, you can type a question into the chat feature that's in the software that you're using right now. So there's a chat, and you can type in any question, hit enter, and it'll come to us so that we can talk through that question. A couple of things. I'm going to share just one example personally, Will, that I've had in my own life. Someone in my family had done some trust planning, but they did not review their beneficiaries. So their beneficiaries, they had left one another as primary beneficiary, had no contingent beneficiaries at all, and they both were unfortunately killed together in a car accident. So then everything that they had kind of done was kind of bypassed because there was no contingent beneficiaries. So I would just say beneficiaries are incredibly important. Also, I guess one of the questions I have for you would be, you've talked a lot about probate and how a will doesn't bypass probate and how costly it is. So what is the process? If I didn't do anything in that scenario where something had to go through probate, what does that even look like?
If you didn't do anything?
Mm-hmm.
So the process of an asset going through probate With a will, you're saying, or without a will?
I'm sorry, with a will.
Will. Yeah, so basically, your will, the will is admitted to probate. So usually, your executor or trusted person, they would know the location of that will. The original has to be submitted to court. There's a probate judge or county clerk who will review the document and then set a probate proceeding basically for the formal distribution or appointment of somebody to distribute assets. So without a proper beneficiary designation, or if the asset is somehow not listed in the will, that's either, hopefully there's a residuary clause in the will, but that opens up a ton of Pandora's box in terms of possibilities. It also means that that asset is probably going to be tied up in probate or probate court for some time, which costs you in a couple ways. So it's going to cost you for the time that it's in probate, time to discuss its proper handling of it, and then it's also going to cost you. You would have otherwise had access to those funds throughout this entire time that probate's been carried on. So usually those assets are frozen, meaning if they're invested assets, you have no control over the management or investment of those anymore, or they're kind of liquidated in cash. So it can cost you in a few ways, but yeah, that is a beneficiary designation is very important. The other one I'll say is consolidation. So if you're a person that's worked at multiple places, multiple 401ks. First of all, that's a lot of phone calls and institutions for beneficiaries to communicate with and talk to. Second, how can you be sure that the 401k that you had at the previous company 10 years ago, are the beneficiary designations there what you're looking for? Do they match the wishes that you're looking to carry out? So consolidation allows you to have all that stuff in one place, so you can have eyes on it, but it also makes things a lot easier on your beneficiaries because, like I said, it's less places and less assets to track down, and less legwork to do.
Absolutely, that's great information. The other question that I think has come up often is, so I've already done some planning. How often should I update these documents? What's the value of doing that?
Yeah, so I would say absent any family circumstances or special events that may happen, I think annually is fine, definitely. But like I said, that could definitely change with any major event. So influx in cash, or the opposite of that, major health event, or marriage or grandkids coming, stuff like that. So absent a life-altering event, we'll call it, I would say annually is plenty fine.
Okay. Other questions? I know that there were other questions that wanted to be asked. Any of the advisors on the call have additional questions that they'd like to share? I think Katie may be trying to share something, but you're muted.
Classic. I was just going to ask you, Will, a lot of married couples tend to think about healthcare directives. Like if they're married, then they're covered because then their spouse can just make medical decisions for them. But I've seen cases where a client might be in a hospitalization situation and different family members have different opinions about things. So can you speak to that a little bit?
Yeah, so normally your wife or someone's spouse would have the ability to at least receive information about care in terms of what type of care and things like that. So if there is no power of attorney that is properly executed, usually that is left up to the hands of the professionals to decide what type of care is best for you, and ultimately when you should start or stop receiving that care. But the best way to take care of that is, one, you name your spouse as the primary agent on your power of attorney, but then you can list as many alternates as you want. So usually the best thing to do there would be spouse first, and then if you have any children, you can either put them as co-alternates, put them on the same footing for decision making, or one over the other, and then just kind of go down from there. But yeah, it's a lot of it is if you're finding a doctor who plays by the rules, they're going to keep a lot of that information private, just to attorney doctor-patient privilege. But power of attorney document can solve all that stuff, and they're super easy to get done. So.
Yeah. The other question, Will, I get a lot with clients that still have, kids at home, and we're doing some trust planning, is like, how do I decide what ages, that my kids can receive the money that's in trust for them? Do you have any thoughts on that?
I do. So obviously, it's every family's different and every kid is different. Some may be ready to handle a lot of money at 20 years old. Some may never be ready. The most common ages that my clients employ in planning is 30 years old or 40 years old. That's when their kids have access to potential trust left in their name. Some clients split it up, so half at 30, half at 40. And then, like I said, some people do specific, goals that must be met, either graduate from college or, get married, stuff like that. So I would say if you're concerned about, spendthrift activity, then you may not put, it may not be an age number on there. It may be, hey, this is how much this person is entitled to, per year, as to not give them the opportunity to kind of squander everything if they're too immature or irresponsible, for any given age.
Thank you.
This has all been really, really good information. Oh, sorry, Matthew, did you have something?
Yeah, I was just going to ask Will one quick one. I knew that some legislation back in 2020 into 2019, that was Secure Act 2.0. There seemed to be a lot of attorneys across the country that were scrambling to update language in trusts. Can you chat about that just a smidge and probably highlight why people need to review their trusts if they've been in place for any length of time?
Yes. So actually, so after Secure 2.0, it was actually during COVID, the estate tax exemption level was lifted. So basically, they lifted the number you have to get to when estate taxes apply, and they raised it from about 4 million per couple or per individual to almost 7 million per individual. So they're calling that, it's a sunset on the provision in the original legislation that was passed. And what a sunset means is that law is in effect, but for a certain amount of time. So it is set to expire actually at the end of this year, the sunset. And right now that number is, I think, 7 million. If it expires and no legislation is done, it'll go back to that 4 million level, meaning anything over 4 million would be taxed at that 10 to 25% mark instead of 7 million, which gives you $3 million more of cushion. So, can we bank on legislation being passed before it's our time? No. I don't know about all of y'all, but usually the government I found to not move at the quickest of paces. So something that you would want to just kind of take care of instead of hoping that the people in Washington are able to, get it together and help you out.
That's absolutely good advice. And that's another reason why I think offering at least a second look of what you've currently done is really important. Again, you can use this link. You can reach out to your advisor. We can connect you with Will if you want to go that direction, or maybe you just want to talk specifically about some of the topics you brought up today. We did some basic things here, but you talked about some more advanced strategies, like an irrevocable life insurance trust. If you're not sure what that is or how that might affect you, that might be something to speak with your advisor about. So again, Will, we really appreciate all of the information and the time you took to give this information to us. Again, we hope to connect with each one of you about your estate plan and talk through how you might make changes to that, or maybe it's just great the way it is, but let's at least review and make sure that it does exactly what you intended it to do. So from all of us, we appreciate you today. Have a great day, and we'll connect soon.
Thanks, everybody.